And now we will be transitioning to the second half of our day. So it is my pleasure and my honor to introduce you all to Nancy K. Kaufman, the CEO of the National Council for Jewish Women, NCGW, who will be offering a couple of very brief remarks to kick us off and send us into the second half of our discussion. So please join me in giving a warm round of applause for Nancy.
Thank you. Thank you, Megan and John and Sarah. We've been honored and really it's been great to be co-chairing and co-convening the Coalition for Liberty and Justice with Catholics for Choice. I just want to recognize Amy Cotton, who's been our staff person, who's worked tirelessly with Sarah on putting this together, and Sammy Moschenberg, who's our director here in DC, who I know needs no introduction. So I just wanted to begin by saying that the National Council of Jewish Women, I think as many of you know, is driven by progressive Jewish values, and we are dedicated to improving the lives of women and children, and also to safeguarding individual rights and freedoms. So it's two parts of our agenda, and both are equally important to us. As we've been learning today, many of these rights are under attack. And we don't have to look very far to see how some in our society are seeking to impose one religious view on all of us. Some examples. In Vermont, a country inn declined to provide a wedding reception for a same-sex marriage. In Hawaii, the owner of a bed and breakfast refused the double room to a lesbian couple. Both said providing service would violate their religious faith. More recently, as we all know, the Federal Appeals Court judge ruled that the evangelical owners of the Hobby Lobby, the arts and crafts chain, may have the right, based on their religious beliefs, to refuse to include contraceptive coverage as part of employees' health insurance plans. For some time, the pharmacists have asserted, some pharmacists have asserted, and in many states have won, the right to refuse to provide contraception based on religious grounds. Refusal to serve and using religion to discriminate isn't new. In the mid-1960s, Lester Maddox claimed biblical justification for his refusal to serve blacks at his Atlanta restaurant, which he famously defended with axe handles in his campaign to become Georgia's governor. Throughout the 19th century, women were refused entry to taverns, professions, and really to anything that a proprietor decided to exclude them from. The second-class status of women was often, if not always, justified by biblical text. What do these examples have in common? They all involve the entanglement or disentanglement of religion and commerce. After the Civil Rights Act of 1964, a new benchmark was set for business behavior. Once you hung out your shingle, you could not discriminate on the basis of race, religion, national origin, or sex, regardless of your religious justification or personal belief. Ironically, the reemergence of attempts to claim constitutional protection for discriminators over those discriminated against is a measure of the success of the expanded vision of the women's rights and gay rights movements. On these two issues, a full understanding of equality has brought us to a new contested territory, that women's health inevitably includes reproductive health services, and that same-sex relationships deserve the same respect under law as heterosexual relationships now enjoy. The Affordable Care Act provides a range of reproductive health services for women, including contraception, as an essential part of health care. To deny essential coverage to women, but not to men, think prostate surgery, Viagra, etc., is discriminatory. We've been here before when Congress enacted the Pregnancy Discrimination Act of 1978. It recognized that being pregnant and being female were inextricably linked. Yet at the same time, the pharmacist's refusal example has spread with odious effects. When some claim the rights on religious grounds to refuse to fill a prescription or pay an insurance premium that includes contraceptive coverage, it is not just the employer or educational institution that has an interest at stake. A woman's freedom of conscience, her ability to exercise her own moral and religious beliefs, is being trumpeted by the views of her employer. If refusing to include insurance coverage of women's reproductive health care becomes legal, women will be forced to choose between their jobs and their own well-being, their autonomy or their pocketbook. And there won't be much logical distance between those who would deprive them of health care and those who would deprive anyone of a hamburger at a lunch counter. The fight for women's equality closely mirrors the fight for legal equality for lesbians, gay, bisexual, and transgender Americans. Public opinion has moved toward legalizing same-sex marriage, affirmed by the recent Supreme Court decisions on marriage equality. Just as we must protect women's access to contraception, we can't let victories for gay equality be undermined by allowing individual business owners to refuse service based on a religious claim that same-sex marriage is sinful. We can't relegate same-sex couples to second-class treatment in the public square. If the refusal doctrine gains more headway, then that would enable the hard-won progress that enables LGBT Americans to live free of legally sanctioned prejudice would also be short-lived. So without vigilance, the many jurisdictions that have outlawed discrimination in employment and public accommodations based on sexual orientation would see those laws rendered toothless. So the idea that service could be denied based on religious conviction didn't survive the Civil Rights Revolution and should not be revived now. So it's for this reason that we've convened here today. These are some of the reasons, and why so many of us are concerned as we discussed this morning. We heard this morning about how these issues are played out in our courts. We explored legal questions in current cases and heard from important secular voices. We talked a little bit about what the appropriate role of government is. And we talked about some accommodations being reasonable and appropriate, but many others are not. We talked about the contraception mandate issue and the question of how the court will rule. We talked about taxpayers' dollars should not go to advance a particular religious point of view, and that everyone, we believe, is equal in front of the law. So these were some of the topics that we heard, and we heard, I think, critical perspectives from our faith leaders, highlighting that religious liberty is for people of every faith, as well as for those who don't identify with any faith, with the bottom line being that it is the right of individuals, not institutions, to exercise religion. This afternoon, we will depart from this more theoretical frame that we've been involved with this morning to one about the impact of the restrictions themselves. How religiously motivated restrictions, in reality, have a dangerous impact in our everyday lives. Looking at women's health issues and the rights of LGBT individuals, our partners on the next two panels will highlight what it looks and feels like, what it means for patients, families, students, workers, and others in our communities when Congress or state legislators are allowed to advance one religious view over another and enshrine one view into law. We hope you will continue to gain insights on the key intersections of these distinct policy issues and how they relate to individual religious freedom, and that you will be inspired to join us in the Coalition for Liberty and Justice and protecting religious liberty for each of us in the future. One way to join our efforts in the near future is by activating your networks and leadership to show support for women's religious liberty through access to birth control. We will look to be raising public awareness about how religious liberty is at risk with Hobby Lobby and Conestoga birth control case when the Supreme Court hears the oral arguments on March 25th. So please stay tuned We were part of yesterday, many of us gathered in the women's health community with the religious liberty community, because we do believe it's both and, women's health and religious liberty, to talk about strategy around March 25th and what would make sense. We know that reproductive rights is only one of the issues that we're confronting with this court, but I think we are all concerned in this room about the flip side of the women's health issue, which is the religious liberty issue. And as a representative of the National Council of Jewish Women, who for over 120 years has been working on these issues, I can honestly say we've never seen it so bad. And I think that the only hope and answer will be to enlist our grassroots and to remember what Rabbi Dennis Ross said, to remind ourselves to say thank you to those who've been there with us, and to let those who aren't, who are teetering, or who don't agree with us, that we represent a majority of Americans when we say that we really do believe in the principle of separation of religion and state. So please plan to take action. We'll be looking for people to write letters to the editor, blog posts, social media, and we'll be coming together on the 25th around the court hearing, hoping to make our voices heard. So I just want to again thank our partners at Catholics for Choice for the work putting this together. Thank you all for coming, and I'll look forward to hearing from the panelists as we move forward with the day. So thank you, Megan.
Thank you for joining us this afternoon. Now, my name is Sarah Warbelow. I'm the State Legislative Director for the Human Rights Campaign. Today, we're here to talk about the intersection between religious liberty and the LGBT community. Clearly, religious liberty is at the very core of what it means to be America and what it means to be American. Our country arguably would be radically different today had we not been founded on the principles of religious liberty. But those religious liberties can sometimes come at a cost when they are not actually liberties, but taking advantage and taking liberty with someone else's rights. For the LGBT community, the religious liberties has been used both as a shield and a sword, particularly through the First and 14th Amendments. Today, we're here to look at all the myriad ways that LGBT people's lives are impacted by these efforts on the religious right to promote religious liberties for some individuals over the basic core rights and what it means to be human for LGBT people. I'm so pleased to introduce you today to our panel. Directly to my left is Jenny Pizer. Jenny Pizer is Senior Counsel and Director of Law and Policy at Lambda Legal, the nation's oldest and largest legal organization dedicated to advancing lesbian, gay, bisexual, and transgender rights, as well as advancing equality for those who are living with HIV. Previously, Jenny directed Lambda Legal's Marriage Project and has both litigated cases and developed litigation to advance marriage equality, protect other family relationships, improve conditions for LGBT people at school and work, and challenge the use of religion to discriminate. Next to Jenny is Heather Cronk. She is the co-director of GetEQUAL. She joined GetEQUAL in May of 2010. Prior to her work with GetEQUAL, Heather was the Chief Operating Officer at New Organizing Institute, overseeing operations and expanding programs. Heather has also worked with organizations such as My Society in the UK and with Idealist.org in the United States, always focused on building community and pushing for tangible social change. Born in Temple, Texas, and raised in Lexington, Kentucky, Heather holds a Bachelor's of Arts degree in Religion and Philosophy from Berry College in Rome, Georgia, and a Master of Divinity degree from Wake Forest University Divinity School in Winston-Salem, North Carolina. Frank DeBernardo, sorry, you guys are reversed here. Maya, not Frank, is sitting next to Heather. Maya Rupert is a policy director for the National Center for Lesbian Rights, where her work includes advocacy on areas including federal legislation and regulation on housing, family policy, health, and employment. Maya has been a regular contributing writer to a number of media outlets, including the Washington Post, the Los Angeles Times, the San Francisco Chronicle, and the Huffington Post, where she frequently addresses the intersection of race, sexual orientation, and gender identity. To Maya's left is Frank DeBernardo, who has served since 1996 as the Executive Director of New Ways Ministry, a 37-year-old national Catholic ministry of justice and reconciliation for LGBT Catholics and the wider church community. He's conducted programs on LGBT issues in Catholicism and religion and secular settings throughout the United States. He has published articles in Commonweal, National Catholic Reporter, and American Catholic, and is the author of Marriage Equality, A Positive Catholic Approach. In addition, Frank is the editor and main contributor to Bondings 2.0, a daily blog of news and opinion covering Catholic LGBT topics. He was a keynote speaker at the Conference on Religion and LGBT Issues at the first World Pride event in Rome, Italy, and was a featured speaker at the Interfaith Conference at World Pride 2012 in London, England. As you can see, we have an incredibly distinguished panel up here, and I'm so pleased to have them delve into this issue quite a bit deeper as we move forward. We're going to start with Jenny, so please take it away.
Well, I am delighted to be here and to be meeting and getting to know many of you, I hope, and to be part of this forum, which is incredibly timely. It's been a long time personally since I had a chance to work with Catholics for Choice and some of the other reproductive rights and freedom folks here in D.C. I actually worked for NARAL right out of law school, and I don't want to acknowledge how many years ago that was. But it's wonderful to be here and to focus on the fact that we're engaged in largely the same project at this point, which I see as a charge to illuminate the stark difference between the religious liberty that has been and remains a cherished American value and the misuse of that term to justify abuse of others in ways that are anathema to our American ideals. During many of these intervening years, I've been focused on the way these problems are affecting LGBT people and people living with HIV, and seeing the expansion of the use of religion to justify discrimination in employment, in provision of professional services, especially healthcare services, in education, and in many other contexts. And in particular, how this discrimination affects some of the most vulnerable members of our community who receive services or seek to receive services from often from religiously affiliated organizations who receive grants of public money to provide those services, and yet believe they have a right to discriminate. And what's particularly painful sometimes to hear from folks who call our legal help desk lines is that folks believe that that's permitted and perhaps even appropriate, and that means that people don't get the services they should receive, and they experience a lot of pain in those contexts. So many of us are focused on some similar problems today, and I think that the escalation of the request for religious exemption, the fact that the Supreme Court is now focused on this issue in the Affordable Care Act cases, is prompting many of us to collaborate ever more across issues and populations and geography, and perhaps the increase in the threat is actually creating the opportunity that we need to work more effectively together and to reach the people in the middle of this country who often feel terribly conflicted. And we find that in our discrimination cases, and I'll talk a little bit more about that in a minute. But we are certainly focused on the responsibility that we bear within the LGBT rights movement to reach out and add our voices to the educational call to help more Americans understand what we mean by real religious liberty, what the law is supposed to protect, and to add our voices together to the call to not allow that religious liberty to be abused to justify discrimination. before I focus on some of the particular areas of our work, and some of them were just mentioned actually in the introduction, but I want to give just a little piece of perspective. I feel like I hear people quite a bit these days asking with kind of great, impressed voices, how is it that the LGBT movement has made such lightning fast progress? How can we take lessons from what the LGBT movement is doing? And also sometimes I hear people say, gosh, religion is now being used in all kinds of new ways in a backlash against all the progress that the LGBT movement is making. And I think that both of these comments are both inaccurate and also kind of accurate, and I want to explain a little bit why I say that. First of all, our movement for freedom and equality for LGBT people has actually been pressing steadily forward for quite a long time, since the middle of the last century. It's just that much of America didn't notice. And that's kind of understandable, perhaps, because there tends to be less recognition in the broader public when we succeed, for example, in getting a local government to enact an anti-discrimination ordinance. That gets less visibility than, for example, the campaigns that Anita Bryant waged nationally to get some of those ordinances repealed. And likewise, the progress, some of it at the local level, some of it in the private sector to provide family benefits for employees with a same-sex partner, those often proceed without a lot of kerfuffle, kind of under the radar, and there's a lot more public attention to the roughly almost 36 campaigns to amend constitutions, which rightly were in the press, but that got a lot more attention. So second, the marriage litigation that is now getting wonderful applause for the sudden, brilliant success of the work. Gosh, it just suddenly happened, and actually those first cases started in the early 70s at the very birth of the modern stage of our movement. And it is certainly true that those cases weren't taken seriously, but they were the beginning of the presentation of those legal claims and connected to a lot of work that has gone on over the decades to build both the legal building blocks and also to be part of the broader educational work and political work that has led to this wonderful moment now where we can have overnight success. And so, I ask, has this progress been fast? Is the use of religion new? Well, it depends what we mean by these terms. If we consider the full sweep of human history, then, sure, it's been fast. If we consider the decades of work by people who have been devoting their lives to it, some of whom are now senior citizens and have devoted their entire lives to the work, well, I think it doesn't seem that fast to them. Although the success is ever sweeter that some of it is happening within the lifetimes of folks. And I think in particular of how sweet it was to see Phyllis Lyon and Del Martin be able finally to marry in San Francisco, first couple in California to be able to do that while they both were still living. That was a sweet moment indeed. So third, considering religion in particular, religious claims have always been a central part of the opposition to requests for equal treatment and inclusion by LGBT people and same-sex couples. I think in particular of the city of New York. I mean, the first local non-discrimination ordinances were enacted in the 70s, thus inspiring Anita Bryant to get excited. But in New York, which was, the promised land and the refuge for so many queer people across America who came to New York, Greenwich Village in particular, and there was the gay rights bill there stalled year after year after year due to concerted opposition from, big surprise, the Catholic Church and Orthodox Jewish leaders, and it didn't pass until a good way through the 1980s. So that's not new, but the advocacy in state and local legislatures now and in Congress, the creation of so-called religious liberty caucuses in the states, and the expansion of the demands for religious rights for corporations to discriminate, that's a new level of boldness, aggressiveness, I think, and that's alarming. But again, it also puts this issue into a brighter public spotlight, and it's bringing many of us here together today. And so we can look on the brightened side. I think it is allowing us to connect to each other more and perhaps have some good success at pushing back on this. So we have continuation and we have expansion of the problem of misuse of religion. And I want to just highlight, and I imagine you probably spoke about this some this morning, but what we see in our litigation, we see it in the opinion research, the extent to which so many members of the public are sincerely conflicted on this issue. And by this I mean in particular the use of religion as an excuse for discrimination against LGBT people, that there is a deep respect for people's religious views and requests for accommodation. And there's also sincere empathy for the harm that is caused by discrimination against gay people. And so thus we have the educational project and also the legal project ahead of us. I want to flag a couple of areas of focus in our litigation, a couple of which were already mentioned, but to give you some categories, and I think my colleagues are going to talk about this more. First of all, workplace discrimination, which is among consistently the largest area of calls for help to our help desks in our offices in different parts of the country. An enormous amount of what's reported to us is workplace harassment in the form of religious proselytizing and religious harassment. And a particular challenge for many of the people who call is that the law presently is very confusing. Less than half of the states have explicit protection against gender identity discrimination and sexual orientation discrimination. We don't have explicit protection at the federal level. And there's a lot of confusion among employers about whether Title VII, the federal non-discrimination law, requires accommodation, or the extent to which it requires accommodation of religious rights of employees, which often takes the form of a desire to proselytize against to coworkers and so forth. So confusion in the law is not helpful, and a widespread belief among employees that they don't have protection makes it worse. On the bright side, we now do have some good settled case law that employers who do not read Title VII that way and do say no to religiously motivated anti-gay harassment at work, they are entitled to do so. So that's a good thing. In healthcare services, we see consistent problems of religiously motivated discrimination and refusals to treat LGBT patients like other patients based on a mistaken overreading of the Conscience Clause protections that apply to just a couple of particular things. We see this in particular with respect to access to infertility treatment. We also see it sometimes with respect to access to gender reassignment care, and sometimes with respect to care that has nothing to do with gender identity or sexual orientation, just a religious objection to an LGBT person. Again, one of the problems that we've encountered in the discrimination, or something I've come to see through my work, is the number of physicians and other health professionals who seem to sincerely believe that if they're doing something for a religious reason, that's not discrimination, because actually following religious teachings is what a good person is supposed to do. They're trying to be a good person. It must not be discrimination because that's what bad people do. And so we do have a big challenge ahead of us. We have this whole category of goods and services related to weddings, where there's been just this explosion of discrimination, whether it's wedding venues, wedding cakes, wedding dresses, photography, the range of things. What's particularly perplexing to me about these cases is that I'm very confident that people who are choosing to go into that line of work to offer those goods and services are not routinely asking potential customers what their religious background is, whether they're in an interfaith relationship, whether either of them has previously been married and is now divorced. It's really a selective application of religious judgment of same-sex couples. And, you know, maybe that's because it's more obvious when the couple presents themselves, but the fact is it's not consistent, and that's something we need to make clear to people. The law really doesn't permit that. I guess I want to conclude with with two things. One is that the law, we have a host of questions now about the extent to which religiously affiliated organizations should be free to discriminate. Frequently, they're simply not covered by anti-discrimination laws. And in the bigger picture of this work, I think that that needs to change. Maybe not 100%, but certainly when there's professional licensing involved, when there's other health and safety regulation involved, when there's public money involved, when there's a school conferring a state-approved diploma, there are all sorts of reasons why there should be limits on the freedom to discriminate. In the legislative arena, which my colleagues are going to talk about, there's a couple of developments that I'll flag as categories and hope that they'll fill in. First of all, we're seeing a push for broader exemptions to non-discrimination laws when we are seeking the freedom to marry or other family law protections. Those two areas haven't been connected before. The request for equal treatment with respect to family law protections the price has never been to give up your protection against discrimination at work or in the marketplace. So that's new. A push for expanded exemptions in the non-discrimination bills that we're proposing. And then the larger area that I'm sure many of you are focused on, the efforts in many states to have just broader protections for religion across the board. The Religious Liberty Protection Acts or Religious Freedom Protection Acts, many of which, if you look at them closely, have selective elimination of some of those qualifying words like substantial burden on religion before the government has to justify enforcing a law. Without those qualifiers, it's hard to imagine how government is going to function, really, and I guess that remains to be seen, but we have a lot of work ahead. So I'm going to stop there and hope that this has given you some sense of how the work on behalf of LGBT people and people living with HIV interfaces and overlaps with the work in a whole host of other areas, and to say I look forward very much to the expanded collaborations that will allow us all to have greater success. Thank you.
Thank God for lawyers, right? I could not have done that. Thanks, Jenny. As Sarah mentioned, my name is Heather Cronk. I'm one of the co-directors of an organization called GetEQUAL. And I come at the question of religious liberty from primarily two perspectives. First, as a seminary graduate who was raised in the church. Second, as a queer woman. Let me unpack that a little bit. My mom has been working on unpacking that for about 10 years now. I was raised in the Methodist Church, went through confirmation, was a leader in my youth group, headed to college to major in religion, and then headed to seminary. I entered seminary as a young, very naive, relatively conservative individual who had a lot to learn about what faith means and what faith looks like in the real world. I was taught by classmates and by professors who had to answer those questions at bedsides, in hospitals, in funeral parlors, very different from the theoretical understanding that I had of religion. It was in seminary that I learned about social justice and the undeniable role that faith communities have played in every single American movement for social justice. It was also in seminary that I came out as queer, and I couldn't have picked a better time and place to do so. Probably words you will not hear uttered very often. My classmates were immensely supportive, and as I wrestled with what my queer identity meant for my religious identity and vice versa, I had the full support of a faith community that I loved and that loved me. It actually kind of makes me a little teary just to say that. One of the most remarkable moments I experienced in seminary actually fused those two questions of queer identity and religious identity together for me, and continues to create an open question for me to this day. One day in our Introduction to Theology class, two of my classmates got into it over infant baptism. One classmate was from Nigeria, one classmate was from North Carolina. Both were Methodists. I went to Wake Forest Divinity School, very broad collection of religious traditions. So it was not at all unusual for us to fight over theology. It was unusual for folks who shared a denominational background. They were both Methodists, to be in disagreement. My classmate from Nigeria was maintaining the validity of infant baptism. My classmate from North Carolina was questioning that practice. I swear this will come back to religious liberty at some point soon. As things heated up, my classmate from Nigeria began talking about the long tradition of infant baptism and the value of placing the support of one's community behind an infant from the beginning of that individual's life, while my classmate from North Carolina was questioning whether a community could even make that kind of pledge to an individual at birth. Suddenly, my classmate from North Carolina leaned across the desk, pointed at our friend from Nigeria, and said, "If you're going to believe in infant baptism, you'd better be careful who you baptize." In that moment, I was both stunned and horrified. And I felt both of those things because her breathtakingly honest point was that the church, the Methodist Church, but also most Protestant denominations and the Catholic Church, was making promises they couldn't keep. The church was pledging its support to infants through a holy ritual, but was immediately going back on that pledge the moment that individual came to the realization that they were lesbian, gay, bisexual, or transgender. That question has remained an important one for me, not simply because of promises made or broken by the Methodist Church, but because exactly the same question can and should be asked of our government. When an individual citizen is born in this country, our government makes promises to that individual. Life, liberty, the pursuit of happiness, yada, yada, we all know these things. But the moment that individual comes out of the closet, those things are stripped away. Those promises are revoked. Those pledges are destroyed. LGBTQ Americans are welcome to come out of the closet, but we lose legal protections the moment that we do. Much like my classmate from North Carolina said about the Methodist Church, the United States has some serious questions to wrestle with about who the government deems as worthy of full citizenship and full equality under the law. As a seminary graduate, I fiercely defend religious liberty. That was baked into my consciousness in seminary and beyond. I fully defend the need for religious and spiritual communities to communicate their theologies and doctrines however they see fit. However, that doesn't mean that religious liberty, or freedom of speech for that matter, exists in a vacuum. There are no absolute value bars around religious liberty. We're facing a religious crisis right now. The radical right has decided that they aren't winning the war to prevent LGBTQ equality, and so they've taken on the war for religious exemptions. However, that's actually not the crisis. The crisis is that many moderates and even many liberals across the country are playing along. We saw this happen just last fall around the Employment Non-Discrimination Act, or ENDA. There is currently no federal law, as Jenny mentioned, prohibiting discrimination in employment based on sexual orientation or gender identity. Yet 3/4 of Americans support such legislation. Even with that massive support, most LGBTQ organizations, including some in this room, and including my own until we were better enlightened around it, embraced a version of the legislation that included loopholes, that included religious exemptions for institutions like universities and hospitals that could claim a marginal attachment to religious history or doctrine. If LGBTQ folks ourselves don't believe that we deserve to be fully equal under the law, we never will be. We see this happening with LGBTQ issues already, but we ought to learn the lessons of the choice community on this, with corporations like Hobby Lobby and Conestoga taking the question of religious exemptions all the way to the Supreme Court. Those who value dignity and equality should remain vigilant of the wolf in sheep's clothing with which we've been presented. That's why these religious exemptions are so dangerous and so harmful. In very insidious ways, these exemptions submit the idea that LGBTQ folks are less than and not deserving of full equality or full humanity. The insidiousness is even worse in red states, like my home state of Kentucky, where my parents still live, where these kinds of exemptions actually roll our work backward. There are loads of folks in those places, from North Carolina to Mississippi to Texas and beyond, who love their gay kids and would never think about betraying that support, except when they hear from religious communities that it's okay, except when they hear that it's completely acceptable to be Christian and homophobic or transphobic and a loving parent. We must resist those tendencies and must create ample space for religious liberty while not compromising the belief that all people are created equal and must be treated equally under the law. Working with GetEQUAL, a national grassroots organization focused on social justice with a particular lens toward full LGBTQ equality, I see the impact of these exemptions on a daily basis. And the most egregious offenders are Catholic schools, where there's been a wave of firings of LGBTQ teachers at schools, mostly after those folks have worked years in the closet and finally decide to marry their partner. Make no mistake, though Don't Ask, Don't Tell was repealed as military policy in 2010, there is still a very live Don't Ask, Don't Tell policy that exists from coast to coast in this country. That Don't Ask, Don't Tell policy applies in workplaces and immigration counters and schools and police stations and all of the other places where LGBTQ discrimination manifests both loudly and quietly across the country. I know we'll get more into conversation about all of this as we move into question and answer, which I'm very excited about. It's my hope that we, and by we, I mean every person in this room and joining us virtually, can work together toward a day when those lines don't exist, when religious liberty and LGBTQ equality are both fully respected and fully operationalized. Until then, the question from my North Carolina classmate years ago will continue to echo in my ear and will continue to fuel my work and the work of many others across this country until we are no longer forced to delineate who qualifies to be fully equal under the law. Thanks.
Good afternoon. It's really a delight to be here and an honor. My name is Francis DeBernardo, and I serve as the Executive Director of New Ways Ministry. As someone who works for a Catholic organization that works for equality for LGBT people, it can sometimes seem like we are living in a new era because of the many positive statements that Pope Francis has made over the less than 1 year that he's been in office. His statements seem to indicate that he is much more open to discussion of these issues than his predecessors have been. But whenever he comes out with a bold statement on gay issues that make headlines, I end up having to work late at night, several nights a week. So now when people ask me what I think of the new Pope, my most honest answer is, even when he says something right, he makes my life miserable. But it's better to work late for something good than for something bad. And there still is a lot of work to be done, even with the new Pope. A lot of work because any possible change that he may influence is still a long way off. Particularly when we discuss LGBT issues in the context of religious liberty, the conflicts in the Catholic Church are still very much alive in the United States. On the one side, we have the vast majority of Catholic bishops who are claiming that any advancement of LGBT rights is an infringement on the Church's ability to set policy for its own institutions. But on the other side, we have the vast majority of U.S. Catholics, lay people, who poll after poll keep showing support equality for LGBT people, and they do so out of Catholic principles, because, not in spite of being Catholic. As these studies show, Catholics poll equally with the American people on support for LGBT issues and on the question of marriage equality, even ahead of the general American population. The failure of the U.S. bishops' 2 Fortnight for Freedom projects over the past 2 summers demonstrates that Catholic lay people are not behind their leaders on these questions. What makes Catholics support these issues? Sarah examined that question this morning, so I'm just going to cover it briefly here. She did a great job. The Catholic Church has a vast tradition of teaching and principles known as the Catholic social justice tradition. These teachings stress, with the absolutism that Catholicism is famous for, the absolute imperative to respect the human dignity of all people, regardless of their state or condition in life. The teachings stress the radical equality of all people, even before the law, that no one should be treated as second class. These principles stress the importance of protecting the rights of those marginalized and vulnerable. Catholic people have been taught well, and they have applied these principles to LGBT persons. At the Second Vatican Council in the 1960s, these principles of Catholic social teaching were also applied to religious freedom in a good way. And Catholics were encouraged to move from a position of converting people from other religions or proving their beliefs wrong to a position of openness, respect, and dialogue with other faiths, and making sure that all people were allowed to worship as they chose and to follow the dictates of their consciences, the ultimate law. Unfortunately, under the previous 2 papacies of John Paul II and Benedict XVI, we've seen the hierarchy shift away from this openness and return toward a more defensive Catholicism concerned with protecting its own principles and institutions. In the Catholic world, nowhere are religious liberty and LGBT issues more controversial than today than in the arena of church employment. Over the past 2 years, as marriage equality spreads from state to state, we've seen a growing trend of LGBT people being fired from their jobs as school personnel and parish ministers because they have married, have expressed an intention to marry, supported marriage equality, and in one case, because of a gender transition. I have a handout here that I'll make available to people of all of the firings that we've been tracking over the past 3 years. In 2011, there were 2. In 2012, there were 4. In 2013, there were a dozen. And right now, there have been 3 already in 2014, when at this time last year, there was only 1. The institutions which do the firing have all claimed either ministerial exemption from employment laws or hid behind the idea that employees have signed pledges to uphold church teaching. Both of these principles have been belied by the latest case, where a food service manager had a job offer rescinded because he was legally married to his husband, and he had not signed any oath, and a food service job is hardly ministerial. What we have seen, though, is outrage and organizing on the parts of Catholics, young and old, in response to these firings. The fact that many of the firings have happened in schools means that the younger generation, which, as we know, is far more progressive on LGBT issues than their forebears, and who also see LGBT issues as the civil rights issue of the day, they have these settings have provided very fertile ground for active protests. The case in Seattle, which happened in December, has seen demonstrations and walkouts now going into their third month. And it's probably the most visible example of this type of response. Their vice principal had been fired because he had married legally in Washington state. But the students are not alone in their advocacy. Their witness in Seattle caused one Jesuit pastor to reflect on their action in a sermon. And I'd like to read an excerpt from that. He said to his congregation, "In the last few weeks, the students of Eastside Catholic High School and their companions from other schools in the area have given us an example of the kind of passionate discernment motivated by the gospel that characterizes an important dimension of Catholic education, and indeed should characterize our faith both in and out of school. Regardless of the particulars of this situation, these students have spoken up as products of Catholic education, as women and men motivated by the Spirit and by their own experience of grace. Though it is a painful time, their teachers and their parents should be proud of the gospel spirit that has been planted in these young hearts. Likewise, we in the broader church should be grateful for what these young people bring and should listen with compassion and openness to the spirit that moves within them. Their love, their gentleness, their quest to make of the church a home for all demands more than the silence of authority. It demands communion and engagement with the church, education, direction, and dialogue. While inspiring, unfortunately, legally, those who protest these firings are on shakier ground. There is hope that in the case of a woman fired from a Catholic school because of her gender transition, that she will be able to bring her case to court. At New Ways Ministry, we have been promoting the idea of trying to get Catholic institutions to adopt non-discrimination policies based on marital status, gender identity, and sexual orientation. And strange as that may sound, it's not a far-fetched idea. As early as 1973, St. Vincent's Hospital in New York City established an employment non-discrimination policy based on sexual orientation. This past summer, 2 Catholic hospitals were lauded by the Human Rights Campaign for their sensitivity to LGBT issues, including employment. And in March of 2013, the lay people and church workers of the Diocese of Santa Rosa, California, persuaded their bishop to retract an orthodoxy pledge for diocesan employment contracts. Developing such policies in Catholic institutions can go a long way to protecting the employment of LGBT people. Catholic universities and hospitals already are leading the way in this area because they know that they will not attract qualified personnel if they don't. The market, as much as theology, seems to be governing the decisions there. In the future, when those Seattle high school students become parents, will they want to send their children to institutions that discriminate? I don't think so. So again, we're going to see the market as well as theology govern here. Just this past week, I was asked by a pastor how he can best prepare his parish for the moment later this summer when his music minister will be marrying his male partner. Aware of the problems that have transpired, this one parish is already looking for ways to avoid such catastrophes. The Catholic struggle for true religious liberty that is tempered with justice still has a long way to go, but I'm not worried about losing my job anytime soon. The fact that more and more Catholics are supporting LGBT equality and justice show that the road will become much easier. Thank you.
Thank you all so much for being here today. Again, my name is Maya Rupert, and I'm the Policy Director at the National Center for Lesbian Rights. And I apologize because I haven't been able to be here for the entire day, and I wish I could have, because I would have loved to hear what people had to say this morning, because I think that these are issues that, you know, we need to sort of explore more, obviously, but also, you know, it's so sort of useful to think about these issues in a way I think sometimes we aren't really conditioned to, especially in DC. It's so easy to silo sort of every single issue and say, this is how religious liberty interacts with, you know, reproductive justice issues, and this is how religious liberty interacts with LGBT issues. And I think what we really see is that there are so many intersections. There are so many ways that these issues really do sort of overlap and intersect. And so I'm glad we're getting a chance to do this and sort of talk about it more fully. And I wish I could have been here for the earlier conversation. I think one of the biggest challenges with looking at the issue of religious liberty and LGBT equality is that there is this assumption that these sort of issues are at odds, and we need to figure out how to sort of navigate and work toward one, almost in some ways it seems almost at the expense of another. And I think that one of our challenges has to be switching that framework. I think that it's a very unnatural way of looking at the concept of religious liberty for a number of people, and I see this especially in LGBT communities of color. I would say especially in the Black community, because of the tradition of the church as being a bastion of equality, that this is where the civil rights movement was born. And so the idea that we somehow have to fight against faith communities in order to get to equality it's sort of an unnatural one, and it's one that sort of gives people pause. And so I think that really, in order to look at this issue in a way that is inclusive of the entire community and is sort of conscious of our history as a movement for equality, I think it's useful to try to properly situate the movement within faith, sort of faith communities. There was a movement that was, I think, incredibly telling and incredibly positive around marriage equality. There has sort of historically been this idea that that a number of communities of color, the Black community in particular, is somehow sort of more homophobic than other communities, and that was especially true of the Black church. And there was a movement called the No Wedge campaign, where a number of Black faith leaders, you know, specifically sort of signed on to something that was actually, that the whole point was saying, you will not use my race, you will not use my church as a wedge on this issue, which I think is, it was an incredibly powerful movement. It was incredibly, I think, it meant a lot within the LGBT community. It meant a lot within the Black community, and it meant a lot, I think, for those people for whom these issues simply are not at odds. And I think that campaign and that movement that we've seen has been a really telling one, and one that I think we want to sort of keep in mind as we think of these issues. A lot of people think of communities of faith as where equality is born and moves from. It's not really something that we sort of have to fight against. Now, that said, obviously, I think, you know, what we're sort of exploring here today is kind of really the misuse of the term religious liberty and and using these issues for something that they really aren't naturally about. And I want to start and talk about something we haven't really gotten to get into as much here, but one that has, this is sort of one of the biggest reasons I think it's so important to engage in this cross-movement work. And this is the issue of refusal clauses, sometimes called conscience clauses. And I think, you know, a number of people who are involved in this work through RJ are familiar with these clauses as basically provisions that were allowing healthcare providers to refuse certain services. If they didn't want to perform abortions, if they didn't want to provide contraception, these clauses were sort of the legislative implement through which they could say, I'm not going to provide this kind of service. One of the reasons I think it is so important that we don't think about sort of RJ over here and LGBT issues over there is that there are so many times that there's an attack that is aiming at one of these communities that will have a horrible impact on you know, sort of, sorry, you know, sort of have an impact, you know, sort of cross movement, and this is one of those areas. what we saw was a movement to create these incredibly broad exemptions that allowed healthcare providers to refuse to provide certain services. And that in and of itself is bad enough for anyone who is dedicated to the idea that all people need to be given access to the health care that they need and have those decisions made based on medical necessity and not the personal feelings of a provider. But what we've also seen is because they were written so broadly and so, sort of across the board, there are at least 44 states that explicitly have laws talking about the sort of right to exercise conscience and refuse to provide certain services. But because they are written so broadly, what we've seen is that they have been used to refuse not just services, but services to certain people. And so it stops being about, a given, a healthcare provider not wanting to provide a certain service. One, they're not just used for individual providers, right? They're being used for entire institutions. But two, they're being used so that a provider can say, I don't want to provide this service to you. And so, we've seen a number of same-sex couples be denied access to assisted reproductive technologies. We've seen, we've seen people simply be denied health care. They've just been denied care because a healthcare provider does not agree with a relationship they're in. They don't, they refuse to affirm their gender identity. And as a result, people, the horrifying thing about a lot of these cases is we've lost people. People will die, obviously, if not given the health care that they need, right? And this is particularly true when we're talking about people living with HIV/AIDS, not being able to get care from the person standing in front of them and having to wait and try and, sort of be pushed off to someone else who's more comfortable serving them can often result in someone dying. There was one case in 1995 that was particularly horrifying. A transgender woman was allowed to bleed to death because when it was discovered that she was transgender, the healthcare provider refused to perform life-saving care, and she actually died as a result of this. And it was sort of relying on one of these refusal clauses that someone was able to say, well, I don't agree with this lifestyle. And as a result, she was not given care. So this is one of these areas where, again, what we saw was an attack that was very clearly aimed at the reproductive justice movement and has bled over and really resulted in certain people, by virtue of their identity, being provided different levels of care. There are obviously, sort of attempts to curtail this. I think that, the Affordable Care Act, having a provision that specifically says, that provides for non-discrimination protections based on gender identity and non-conformity with sex stereotypes goes a long way and will go a long way in making sure that people are protected in healthcare settings. But one, that does not explicitly talk about sexual orientation. So we don't know how that's going to play out for someone who's denied care based on being in a same-sex relationship, for example. And two, we haven't seen regulations on that provision yet. That healthcare, a lot in the healthcare law is still, we're sort of waiting to see how it plays out. So we can't say for sure that this is really going to, how much this is really going to protect people in these settings. And so I think, these are the types of things that we're talking about when we say, we need to, one, reconceptualize the way we're looking at religious liberty, but two, reconceptualize really the way we're sort of doing cross-movement work so that we're not seeing these types of efforts sort of, kind of do this cross-movement bleed. I wanted to also talk about something that I think my colleagues have talked about a bit, but sort of delve into it a little bit more, and that's the issue of marriage equality passing in a number of states, and these sort of the response, we're seeing these religious exemptions pop up as a way of saying, okay, fine, we'll pass a marriage equality law, but here are the set of people who aren't going to, who will not have to provide services in connection with a same-sex marriage. So I think we're going to see this play out in sort of very sharp relief in in the sort of the midterm elections in Oregon, because right now in Oregon there are actually two important ballot measures that are going to be on the ballot. One is to pass marriage equality, but the other is to specifically exempt, and this will be the first time they're sort of getting past it. We're looking at them at the same time. Specifically exempt, sort of businesses, non-religious businesses who are holding themselves out as public enterprise from providing services in connection with those marriages. So the things that, we were talking about, cake makers, people selling wedding dresses, photographers. One of the key cases that the people who put this on the ballot cited was it was Elaine Photography is the name of the case. This was in New Mexico last summer, and the New Mexican Supreme Court declared that a photographer who did not want to take pictures for a same-sex couple for their wedding, that was a violation of New Mexico's non-discrimination law. And so what we've seen a lot are, these cases are, same-sex couples have been winning these cases so far because they've been able to rely on an existing non-discrimination ordinance that sort of can't be trumped by this idea. Oregon, is going to be very telling, because if Oregon is able to successfully pass marriage equality and with it pass an exemption, so they wouldn't have to, sort of go through the courts, they would actually have, sort of legislatively, they would have something saying, if you have a religious objection, you don't have to provide these services, despite the fact that you are a public enterprise holding yourself out as one. If they're able to sort of do that, that is going to make that's going to be a huge shift in civil rights law, the way that we see non-discrimination ordinances sort of, interacting with religious liberty. So I think that's definitely something we're going to want to look out for in the midterm elections, because it's going to be very telling for the next 10 years, really, of these cases, and how states are sort of going to be passing marriage equality laws. I want to stop so we make sure that we have enough time, but I definitely am looking forward to questions, and thank you so much.
Thank you so much to my colleagues who've done a fantastic job at probing every area in which LGBT people find themselves potentially at odds with so-called religious liberties. I really want to take the opportunity to open it up to all of you to ask questions and to take advantage of the wealth of knowledge that is up here. But while you're gathering your thoughts, I thought I'd start us out with a question or two. So for the panelists, I think that many Americans have a passing familiarity with the case of the baker in Oregon or the florist in Washington State who's refused to provide services to same-sex couples. It's been all over the news. And yet, one of our most vulnerable communities often gets incredibly overlooked. How are these fights over religious liberties, and each of you touched on it a little bit, but I'd like to delve a little deeper, how are they impacting the transgender community? Take a stab.
I'll start, and people should.
Thank you, Maya.
Now, did you specifically though want to talk about the sort of the marriage cases, or do you mean just sort of more?
Just in general. I mean, any of the proposed laws, regulations, court cases that are coming down the pike, or those that have been passed, like some of the Religious Freedom Restoration Acts?
Sure. Well, I'll start, and I want to touch on two areas where we see transgender people particularly victimized, and that is, as I mentioned, the refusal clauses that we see in the healthcare setting, and also in employment discrimination. So, and again, in the healthcare setting, so often the transgender community faces such incredibly damaging and alarming rates of discrimination in healthcare settings. There's one of the hard things that we have anytime we talk about this is that it's really difficult to get data. But a couple of years ago, the National Center for Transgender Equality and the National Gay and Lesbian Task Force teamed up and did a survey on discrimination against the transgender community. And what we saw was an alarmingly high rate of people, upwards of, I think 80% of respondents said that they had faced some type of discrimination in a healthcare setting, either being outright sort of refused care, being forced to basically educate a healthcare provider about their gender identity in order to get care, being harassed. Some people reported being attacked. So what we're talking about really is an area where trans people are already so vulnerable, and making it that much easier for a healthcare provider to say, I don't have to provide care. And what's so insidious about it is somehow allowing people to occupy a higher moral plane while they're doing it, to say, it's my conscience, it's against my conscience to give you care, despite the fact that we're talking about a healthcare provider, we're talking about someone who has a responsibility and should absolutely have a responsibility to one of the most vulnerable parts of our community, trying to seek healthcare when people are at their absolute most vulnerable. So that is, I think, when we're talking about the refusal clauses, we really are talking about a high number of trans people, and we really need to make sure that these, that this issue is sort of being talked about in that way. And I'll also then touch on the Employment Non-Discrimination Act. Transgender people, specifically transgender people of color, face alarmingly high rates of employment discrimination. And as a result, people are facing also, obviously, alarmingly high rates of poverty. Trans people are 4 times more likely than non-trans people, either LGBT or just non-LGBT people, to live in poverty and to live in extreme poverty. We're talking about $10,000 or less a year. And so when we're talking about employment non-discrimination, we are really talking about lifting up a community that is in dire need of sort of being done so. And if we have these overly broad and unnecessarily broad religious exemptions, because again, it's not like there aren't already sort of built-in exemptions for religious institutions to make decisions about hiring based on their religion. We're talking about overly broad exemptions, and if we have those are going to disproportionately affect the transgender community.
Jenny?
So a quick thought to add to that. I mean, I think if we have broad religious exemptions enacted in many places before the non-discrimination protections are even there, then the fight to get them will not accomplish nearly as much of the goal as it needs to. And so the people who are already most vulnerable, the likelihood of having safe and non-discriminatory places to work and live and acquire goods and services, I mean, it goes further beyond people's reach. And I do want to highlight this issue of how many religiously affiliated organizations are the places that people need to go when they're homeless, when they're escaping a place where there's been extreme violence, when they're trying to get out of addiction of some kind, when people are new immigrants and are having all kinds of difficulties. And so for the people who are already the most vulnerable, and as Maya said, so eloquently and accurately, our transgender brothers and sisters are among the people who are so disproportionately in those populations. Well, the religiously affiliated institutions often seek and get the public grants to provide the services, and then are free to discriminate. And when it's an environment that is presenting a sort of religious culture, many LGBT people experience that as not welcoming, and so are not even going to attempt to get the services there. So I think we have a big project of preventing the expansion of exemptions, but that's really only just a chapter. And after that, I think we really need to have serious engagement in the process of limiting the existing exemptions. And in particular, as I said, if there's public money to serve people who are desperately in need, that needs to be done in a welcoming way that, that is what the public dollars are supposed to be accomplishing.
If you have a question, please raise your hand. We have microphones in the back, and they're going to be brought down. Let me ask one more question. So each of you raise your hand, please, and we'll get the microphone to you. This morning, the one chamber of the Kansas legislature passed a bill. And this particular bill would exempt not only public officials, but also private individuals, private business owners, from providing wedding-related services. On top of that, if, or perhaps we should say when, the Supreme Court allows same-sex couples to marry everywhere, they're preparing and saying not only should clergy be exempt from providing wedding-related services, performing marriages, but so should public officials, including county clerks, right? Those who are responsible for issuing licenses. What do you think is the long-term repercussions of bills like this, and do you think we might see more as these cases on marriage equality make their way up to the Supreme Court? Jenny?
I'm at risk of talking too much, as usual. I think the big problem is that this reinforces a public message that LGBT people don't deserve to be respected by our own government. by elected officials who are supposed to serve us and by other people in society. And to me, that's the main problem here, I mean, people are certainly entitled to their beliefs. I think, we all share that idea, but when there's a general understanding or accepted idea that people are free to act on those beliefs to the detriment of other people, that reinforces the social stigma that has such a terrible cost for so many people. I mean, if we want the rates of self-harming behavior to decrease among LGBT youth, we have to change the social climate. And the law is often a tool for doing that. I mean, our goal is not that queer people coast to coast should have a right to sue everybody. The point is that people's behavior should change, and the law is a normative tool for getting there.
Frank and Heather, as people who are steeped in religious tradition, how do you talk about or think about a distinction potentially between clergy and individuals who are employed by the government?
Go for it.
Well, I think that it's important for clergy to be allowed to marry who they want to marry. But I think that we have to remember that there is a movement in many denominations for marriage to become ritualized same-gender marriage to become ritualized in these institutions as well.
Yeah, and I would say, I mean, as someone who grew up in the church in the South, I cannot emphasize enough the power of religion to create, as Maya said, to create moral superiority, right? So using a legal tool combined with moral or religious superiority really, as Jenny said, really does create the climate in which LGBTQ youth are hurting themselves or killing themselves, where couples, live in fear, where couples are forced to defend their children against attack. I mean, all of that is, we're dealing with both a legal equality question and a social equality question. The legal equality question has a pathway to solve it. Social equality often then follows legal. And there isn't as clear of a pathway. So, a lot of that stuff, especially around religion, is cultural, which, as the law evolves, culture and society will evolve with it. But we have to have the legal anchor.
Thank you. We have a question in the back.
Hi, I'm Agata from the National Abortion Federation. I had a question. Frank, you talked a little bit about how you were hoping that market forces might influence Catholic schools and kind of what they do. I'm curious if there's been an impact for the businesses who have, refused to provide services. Obviously, I don't think it's enough to rely on the market to kind of control that, but, I'm just curious whether they've seen reduced business in response to that.
I don't know that for sure, but I don't know the negative answer to that. I know the positive answer is that we maintain a list of what we call LGBT-friendly Catholic colleges and universities. And right now, more than half of the Catholic colleges and universities have some sort of outreach or policy or program to LGBT people, either as students or as faculty. And a number of Catholic colleges even provide domestic partnership benefits for their students. Georgetown University was mentioned earlier. They have an office of LGBT equity at a dean's level on their campus, and about 2 years ago they received the largest donation. Their Center for LGBT students received the largest donation that a Catholic college has received of $1 million for LGBT work from none other than the former commissioner of the National Football League, whose gay son is Catholic. So.
Other questions?
I've got a question, if you abortions. And they've come to terms with it because they feel that those doctors should not actually be providing abortions to women. Is there not a similar argument to be made for equal marriage rights? Is that you don't want a photographer screwing up your photographs at your wedding or a baker poisoning your guests at your wedding?
Go ahead.
Well, okay, I'll say, and then please feel free to jump in. One of, I think, the difficulties with that, while I understand the argument behind it and the thought process behind it, one of the difficulties with that is that often it's sort of not as easy as, well, you know, we can kind of shop around, you know, I think you know, I've heard the same argument, honestly, in the RJ movement. It's a great principle to have when we can assume that there are a number of options. If someone can't get an abortion here, they can just go down the street. When we start talking about, you know, sort of rural communities or places where, you know, there's really sort of one place to get all health care, that becomes a much more difficult argument, right? And I think that we see the same thing here. In some areas, there's not photographers. There is the wedding photographer, right? And so especially as we are starting to see how, you know, the sort of assumption that LGBT people sort of move out of their rural communities and move to the cities, we see that that's not true, that a number of people stay in smaller towns, stay in you know, sort of in communities where we can't take for granted that people can shop around. It becomes a lot more sort of difficult to say, well, the people that don't want to do it, then don't do it, we'll find somewhere else. If there isn't a somewhere else, you know, that's really where it gets more difficult.
Customer gets to choose, but the business does not get to refuse. And in providing medical care or some kind of other professional service, if there's really an issue of competence, then it seems to me that's legitimate. But I guess in looking back over the decades of the work to secure reproductive rights, I wonder whether, I mean, not that we can turn the camera back, but whether it was a pragmatic decision or whether it was sensible to go down the path of saying that a standard part of medical practice could be objected to. I mean, for people who hold deeply held religious views about when life begins and who should have assisted reproduction and how people should die, go into fields of medical practice where your views aren't going to get in the way of your patient's needs. I mean, this was the issue for me in the Benitez case when litigating it. Why did these Christian fundamentalists decide to be infertility specialists? You know, they could have done lots of other areas of medical practice where to help everybody without being in the conflict that they created for themselves of having an objection to something that was, whether it's standard of care or whether it's not about a procedure but about a patient. Either way, the duty, as the Supreme Court has said, ought to be on, in the first instance, on the individual who knows best what her own religious convictions are, to find a way of practicing a profession or making a living that isn't imposing those beliefs on other people.
From Medical Students for Choice. And I'm curious about this because from our perspective with physician practice, of course, the real issues we struggle with are in those communities where there are no options. But for pastors in the many, many small communities across the U.S. who are choosing to assert a conscience around something like a wedding, what does that mean from your perspective about the whole array of pastoral care that that pastor provides for their community? You know, just as I would worry about a physician is not only, abortion is not the only service we worry about. We worry about patients who are told they can't have a prescription for contraception because they're not married. Or there is an entire array of behaviors that if we endorse this as acceptable, then we have opened a door to an enormous array of problems. So within your realm and within the pastoral care community, what are your concerns around that?
Well, I definitely think, we're seeing a number of these cases and efforts to limit what is sort of referred to sometimes as reparative therapy, but really isn't either reparative or therapy, and is actually an effort to try and take young people and engage in these change efforts to change their genuinely held sexual orientations or gender identity. And we see very often that this is something that, there have been laws to prevent it from happening from licensed therapists. But we also see it very often happen in churches. And so it's coming from a faith leader. And that is not something that the sort of state can touch. But I think it's exactly what you're sort of talking about. It's one thing to say pastors don't have to perform marriages if they don't want to, but it's another thing to get to a point where people are not harming young people with this sort of that kind of those kinds of efforts. And I think that that's where, there's only so much that can happen from a legal point of view for something like this. I think that's where we have to really shift the way that we engage with faith communities because what we really do have to then focus on is trying to get people to understand the harm that's being done, meeting people where they are and understanding that on some level this is coming from a place of a desire to protect and love, but that it's not doing that. And if we can start having those conversations and shift the way that we look at religion is over here and LGBT equality is over here, I think that's going to be the most effective to prevent things like that, because I don't know that when we're talking about pastors doing it, there's a lot that the law can do.
Mm-hmm. Yeah, and I would say that there's a difference between legal policy and religious polity. And you have to be fighting both of those fights. Polity comes from inside the church or synagogue or religious institution, and legal policy as a whole, that's a legal case that everyone is entitled to equality under the law. So I think both of those are super important. We work with a lot of faith traditions and denominations to influence that polity question that has to come from inside, even as we're fighting the policy question on the outside.
I think we've got time for one.
Can I
please do, and then we've got time for one more question.
I wanted to answer your question also by answering this woman's further answering this woman's question earlier. Is that you may have heard that the Vatican is holding a synod on family, marriage and family at the end of this year, and that one of the incredible things that has happened is that the Vatican has asked bishops, it's only bishops who go to synods in the Catholic Church, has asked the bishops of the world to ask their people about marriage and family issues. And one of the questions that they asked that they're asking is pastoral care for same-sex couples. And asking pastors and parishioners to reflect on that issue and on that question. And I said I would also answer her question a little further along with that, is that I don't know if you've noticed, but after about 2010 or 2011, really 2011, bishops have become a lot quieter about marriage equality. Now, they're still out there, and they're still opposing it, and they're still making it known, but there's not the shrillness that there has been. And a number of people point to Maine, which went through 2 referendums. And after the first referendum, about 1/5 of Catholics in Maine left their parishes. When the second referendum came around, the Catholic Bishop of Maine was much quieter than he had been just a few years before. So I think that bishops are realizing, that it is not a winning proposition that it is pastorally harmful, pastorally and practically harmful to be anti-marriage equality.
Thank you.
Yes, I have a question about, you've talked about refusals by healthcare providers, and I want to ask you about insurance companies, which increasingly are going to be important under the new protections under the Affordable Care Act. So both in terms of what's included in essential health benefits and discrimination claims or theories that could be used there, but also if somebody, Maya, you talked about what the practical reality of a refusal is. If you go somewhere, somebody won't provide you, and this cuts into the reproductive health services, LGBT patients, that if you have to go out of network, you lose the protection of the subsidies, of the cost-sharing subsidies, of the limits on out-of-pocket expenditures. There are huge implications if you have to go out of network under the ACA. And so I'm curious if you've seen any of that. This is all emerging. It's just starting now, and how you've been thinking about it.
I can start with this, sure, because we have seen some of this in two areas. One, in people who are legally married but living in a non-marriage state, trying to get insurance as a couple, and then sort of the problems that they're having with that, and then also in the context of for transgender people trying to access transition-related care through insurance companies. So the same-sex couple example I'll start with because it actually got resolved. A number of people were applying as couples in buying insurance through the exchanges, applying as couples, being granted, but then getting sort of the insurance companies kick you back a letter saying, you don't live in a marriage state, so we can't recognize you as a married couple. That was sort of, there were kind of two issues. There are regulations in the Affordable Care Act that specifically prohibit discrimination based on sexual orientation and gender identity in the exchanges, but then also from any qualified health provider. So any of the any of the insurance companies that are able to sell through the exchanges, the essential health benefits, there are non-discrimination protections both places. So this was considered a violation of the prohibition against discrimination by the qualified health provider because they were able to buy through the exchanges, but then it was the health provider that was saying you're not a couple. It was resolved. People have been able to apply, and so that's been the fact that there are these regulations on the exchanges and with the qualified health plans has been incredibly important for people. The more difficult question is whether or not transgender people can access transition-related care through insurance companies. Most insurance companies include specific exclusions that'll say, even if this is a procedure that we would provide for another reason, if it is related to a transgender person's transition, it's being excluded. It won't be offered. We obviously are taking the position, I think a number of organizations take the position very, very strongly, which I think is the logical position, is that is, by its nature, discrimination based on gender identity, and it should not be allowed to be a position that qualified health plans are taking. We are waiting for regulations from HHS on the ACA to determine whether or not HHS is going to agree with that. So there's definitely going to be a lot around this issue. For right now, we've seen some positive stuff, but we've also sort of seen some continued confusion around it, and so we're hoping that'll get resolved. Do people have other?
I wish we had time to explore this further. No, to borrow a tired but useful phrase, we have only touched on the tip of the iceberg here. And I'm going to take the liberty of speaking for all of us when we say we really look forward to engaging with all of you further on these issues. Please join me in thanking once again our panel for their amazing comments.
Thank you.